everyone around midnight. So where were these people going to sleep? And a lot of these people came here and just were kind of hanging out, going delirious from lack of sleep. And that would be where Pottinger versus Miami comes in, where it's just mean, it's cruel. And if we want to talk about the history, there's also the First Amendment, and that's really where criminal trespass, in my mind, came in. Criminal trespass was created to suppress dissent, to suppress the poor, to suppress those who are powerless, and this really happened a lot during the Civil Rights Movement. In the Civil Rights Movement, the farm workers were organizing in the fields, and so they would go out and talk to farm workers and say, let's organize a union, let's do this, and they were prosecuted for trespassing. You're not supposed to be on this farmland. And so the police continued to do this. People would picket, they say, oh, this is private property, you can't picket on private property, oh, you're jaywalking, et cetera, and they kept arresting all these organizers using, in part, criminal trespass as a spear to destroy the labor movement. And that has been something that criminal trespass has been used a lot, you know, whether it's Pinkertons, whether it's state troopers, whoever it is, it's often used to stop and oppress movements, which is why it has been used to fight Occupy Oakland, which is why that one on over here, when that was evicted, was when people were talking about occupying that, they put up signs, big signs that said, Penal Code Section 602, you know, be forewarned, the powers that be are going to use the laws they wrote to oppress you. Well, in Ali v. Medrano, and also a lot of cases, these prosecutions of people who are organizing were actually considered to be unlawful, in that they were, and this is where it comes in, selective or bad faith prosecutions. And that is what happened over here on 18th and Linden. It was a selective prosecution, so it was a violation of the First Amendment, because I don't know if any of you have ever tried to call the police in Oakland, but they don't come unless someone's dying, or you know, or something, or someone's smashing up, you know, a bank or something. They won't come. You know, you could say, oh, you know, my landlord came by and smacked me, and they're like, are you dying? No, they won't come. I called 911 on landlords. You know, I've been in properties where people have been roughed up, and they hardly ever come unless it's going to get to the point where someone's dying, someone's seriously injured. OPD consistently does not evict squats in Oakland, thankfully, because they don't really give a shit. And the fact that they went down to 18th and Linden in riot gear and specifically sought out the owner the moment anyone popped up a tent that was associated with Occupy Oakland is completely selective and bad faith prosecution. Because, you know, if you were to do that anywhere else in Oakland, the police would not do anything. They would not care, because frankly they have better things to do, or worse things to do, I guess, too. I mean, if we all know that OPD has a sordid history. But so, you know, selective and bad faith prosecutions, if you're singled out like Occupy has been for prosecution, then that has also been a pushback under the Constitution. And so, sorry, I wish I had a podium. At any rate, so let's assume that you're occupying a property and you have not been arrested, but the owner shows up and there's this whole other situation. And so that puts you in another position, because if the owner shows up within the 5-year period, then you are a civil trespasser and there's a civil dispute. And there are a number of things you could do to protect yourself, to create the civil, you know, to create the aura of civil, you know, it being a civil matter and not a criminal matter. And some of those things are obviously setting up residence, registering to vote at the house or the property or whatever, setting up utilities in your name, getting mail at the property, you know, doing things like that, making sure you have keys and have access. You know, police are trained to distinguish people with keys from not having keys, so if you make sure that there's keys and you have exclusive access, these are things you can do. There's also some other more legal things you can do to establish your residence. One thing you can do is under Code of Civil Procedure Section 704.930, you can file a homestead declaration. declaring that you are the resident of the property and that you are the declared homestead owner, which would of course be pursuant to Civil Code Section 1006, which states that if you occupy it, you own it. All right, so then, and I should mention that the homestead declaration is considered to be, evidence you can use in court. So that's always nice because it shows that you were there for a period of time. The other thing you can do is file a notice of intent to preserve interest, so that, for example, if you file a notice of intent to preserve interest and you're in the house for 4 years and 11 months and then the police come by and arrest you, you can have that on file showing that you did not leave the house on your own accord, that you had the intention to continue making a claim on that property. And these things are good because, well, in my experience, I was arrested, I was convicted of Penal Code Section 602.5, I served time, blah, blah, blah. And at the end of it all, the owner still had to sue me, after they testified against me in court, forcing me to serve time. They still had to go through the process that I was due because I filed these papers, which was nice. And I should mention that it's really important when you're doing these things, when you're occupying properties, to be aware of what the risks are. And so, like I said, the biggest risk you face generally, if you're careful and you do everything by the book, is violating Penal Code Section 602 and 602.5. And the maximum sentence you could get from those is 6 months in jail, which really, really sucks. And when I was convicted 3 times of that, 602.5, I was sentenced to 2 months, and then that was transferred to the Sheriff's Work Program, SWAP, and you could get, community service. So it's really good to know what you're putting yourself at risk for, because some people think, okay, this is going to be something really bad. I could go to prison for this, and that's not the case. And some people think it's nothing at all, or it's not a big deal, but it is. You could, serve some time. And I should mention that whenever you're filing documents, it's important that these documents reflect the actual facts of the situation. So when you file a notice of intent to preserve interest, for example, you don't want to say, I purchased the property from some non-existent fictitious person. You want to say, my interest is that under Civil Code Section 1006. I'm an adverse possessor. I'm a squatter. So you want to be honest about that. And because, it's against the law to also file fraudulent documents. So you need to make sure that you file things that are true, not just make stuff up. And I'm trying to think if there's another. Oh, and there's some other documents that you could file. There's also a quitclaim deed if you want to basically, if someone that's part of your group that's occupying a property wants to not be part of the group anymore, it's very helpful for that person to file a quitclaim deed to the other members of that group, so that there'll be a deed on file. And a quitclaim deed doesn't actually say whether or not it's good or bad title, but it's really good to file just to show that there's some kind of evidence that there's something on record. And it's very helpful because you'd much rather be dealing with code inspectors with the city telling you to get the trash out of the yard and mow the lawn than you do, police pulling you out of the encampment in the middle of the night. So that's it. And I would really like it if someone could facilitate questions, because I will not be able to keep track of that. So on that note, are there any questions? And is there a facilitator to facilitate the questions? Because I got 2 questions simultaneously. 1, 2, 1, 2. I'm going to go with him first.
Earlier on, you spoke about that you went to the assessor's office to file. I think it was I don't know. It's one of those notices about. They said they don't do that. The last 2 items about the homestead declaration and the intent to preserve interest are those things that actually work here, or are those?
Well, I filed a homestead declaration, a notice of intent to preserve interest, a quitclaim deed, or not a quitclaim deed, a grant deed actually. Yeah, these are, it's important that you file things that actually exist, because basically what the recorder does is records a certain list of documents, and you can actually go down to the law library, which is on 13th Street next to the Oasis Lounge, and get a book that has every recordable document that exists in the state of California. And you cannot record anything that is not one of the actually lawfully existing documents. They won't do it because people go down there and try to file all kinds of stuff with them, and they say, oh, it's not on the list. And it also has to conform exactly to the specifications. And if you tried to file a notice of intent to preserve interest and they said we don't do that, then it sounds like they're fucking with you. But or you just didn't, there's something missing on the notice. Oh. Oh, sorry. All right. Well, yeah, the notice of intent to preserve interest, they will accept that. But the one thing about the notice of intent to preserve interest is that it has to be based on a previously existing document, which, I usually file the homestead declaration and then file the notice of intent to preserve interest. And I should mention that I was on probation, and the lawyer who was suing me after I'd already been convicted, called the district attorney's office and said, this guy's doing crazy stuff, go after him. And the district attorney said, whatever, this doesn't seem like anything weird to me. So that's just my experience. So I do know that there has been a case where someone filed a grant deed from themselves and to themselves, and that was considered a fraudulent document. So, it's good to be careful. Who was the next person? Yeah, that'd be cool. Maybe we should start a line or something where people, because I can't go out here because it'll start feeding back. So if people could line up, that would be the ideal way to do this. And I would also, I don't know everything about the law, so if people know things, if there's lawyers here, or if there's people that have legal experiences that I missed or I don't know about, please feel free to share that with the group. Otherwise, line up if you have questions.
So, from what I know, if you use a bolt cutters to get take off a lock and get into a place, you can get burglary charges. I've heard. There's laws that may bring up issues around gaining access, and I was wondering if you could elaborate on that.
Good point. Burglary. That may come up if you're, breaking and entering into the building. And so that means at the point of cracking a space, you could be exposed to that. But the weird thing about burglary is that you have to not just enter a property, but you also have to have the intent to commit a crime. And so they might charge you with burglary, but if it's clear that you're there just to find a place to sleep, there has to be some underlying crime. You have to rob somebody, you have to hurt someone, or at least you have to intend to do that. You don't have to actually follow through with it. So something I always tell people to avoid burglary liability is if you enter a property and you find a pot of gold, don't take the pot of gold. Don't if you find a pile of money, don't go to your bank account and put it in your bank account and then spend it in Vegas. If you find something valuable in the house, set it aside for safekeeping, because what prosecutors may try to do, and this still would not be burglary technically, because technically you have to have the intent to commit a crime before you enter the property for it to be burglary. But prosecutors might see, oh, well, he took the pile of money, took the pot of gold, and found the Rolex and did all the stuff with it. So he clearly had intent, and you might be in trouble, even though it's not true. So just avoid doing stuff like that. Make sure that when you go into a property, and are there people lining up for questions? Just curious. Okay. When you go into a property, focus specifically on occupying that property and not doing other things that might be considered dubious later. Yeah, so that's what I would recommend on that. So if there's any other questions, please come up. Otherwise, we'll just...
So I've also gone into squats that have...
I've also cracked open squats that have had copper removed and have had people burglarize them. So like, can that ever legally fall on you?
Well, if you didn't do it, you shouldn't. But I wouldn't think. I mean, that's so common. Like having all the copper removed, that would be impossible to prosecute somebody for that. That didn't, especially if you're not doing it. Now, the person that did it, if they're walking out with copper pipe, yeah, you know, they can get in trouble. But make sure not to, you know, do that. I mean, I buy copper pipe and bring it in, so I'm the one that's having my copper pipe stolen because, I mean, the first thing you always want to do when you're occupying a house, at least, or a building, is make sure that the water works, because the last thing you want to do